Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. This weekly podcast is based on questions that we have received from clients and their families. Our law firm is committed to providing the highest level of professional service through aggressive advocacy and serving as a trusted advisor during a tough situation. To learn more about our law firm, read my weekly blog, watch my videos, or download one of my strategy books, visit GamboneLaw.com or call 215-755-9000 24 hours a day to schedule an appointment. This podcast is for information purposes only and does not establish an attorney-client relationship. Welcome to episode 12 of the Gambone Law Podcast. We are here despite the coronavirus. As a law firm, we have made changes to deal with this epidemic, working remotely, but nevertheless, we are available to handle clients' issues and any issues that come up in the next, what could be 7 to 8 weeks, what I'm being told. It's important to understand that during this time, our law firm is still answering phone calls 24/7. We're available to do emergency hearings. Keep in mind that while courts are closed, some proceedings are still taking place, like bail hearings, which are very important if you are arrested in Philadelphia or anywhere in Pennsylvania or New Jersey where our law firm practices. It's important to understand that a bail hearing will occur at some point in time. It's very important that you have a lawyer there because when your bail is set, that is the best time to argue for a reasonable bail and in some cases unsecured bail. After the bail is set, if you want to have bail reduced, you have to file a separate petition, and it takes time. Also, given the fact that courts are not operating now on a regular schedule, that could be several weeks. So you or your loved one could sit in jail 7 or 8 weeks or even more if courts are not up and running, which could be the case. So I can't stress enough the importance of understanding that everything hasn't stopped in the legal system. If your loved one or you are arrested, it's very important that you contact an attorney, you contact our law firm, and you get in touch with us, and you immediately begin the process of representation. You need someone on board immediately. The second issue I want to tell you is that with regards to emergency hearings, protection from abuse hearings, and temporary restraining orders in New Jersey. So the PFAs are for Pennsylvania, the TROs are for New Jersey. Those are still taking place. So if you are a victim of domestic violence, you can go and file a petition. Those would be considered emergency. Those, as far as I understand, are still operating. So if you're fearing for your life, go out and contact police, and they can direct you to where you have to go to file that PFA or that TRO to keep you safe and keep your kids safe. If that's your situation. I can't stress that enough. Again, at those proceedings, you aren't entitled to a lawyer, but I recommend having one, whether you are the petitioner, the person seeking it, or the defendant, the person against whom it's being filed. In both situations, you need representation. You have to understand that the temporary order is just, as it states, temporary, but if a final order is put in place, it will last 3 years unless the person who filed it withdraws it at some point in time. And if you have those types of orders in place, it will prevent you from, in some cases, returning to your home, owning or possessing or being able to purchase a firearm. So I just want to make those points clear to you that while this virus seems to be taking over the world and it's affecting everybody, including our own law firm, we are here, we are ready to help you and your family if necessary. Okay, so let's go to our questions. First question, this is virus related. Is Philadelphia not arresting people for crimes like shoplifting, drug possession, and DUI during this epidemic? Well, I saw a story this morning about that, and I think it's important to understand that there's a distinction here that most people don't understand. This is a perfect example of really not understanding how the law works. And again, I'm not doing this to criticize anyone for simply not understanding the process, but you have to understand that in this situation, Philadelphia is choosing not to arrest people on site and take them into custody. It doesn't mean that they're being let go. It means that they're being given a summons to appear later. So it may not seem like you're being arrested, but you're being stopped and then being required to come to court and answer for what you did. If you don't appear in court, the judge at that time will issue a bench warrant. It's also important to understand that if the offense that you're being stopped for and cited for is an ungraded misdemeanor, or any misdemeanor offense, you will have a preliminary hearing in Pennsylvania. And again, at a preliminary hearing, prior to that or after it, they are going to set bail. And in most cases, it's a minor offense and the bail is going to be unsecured. But that whole process, you are being charged. So you are being held, and you, for that period of time, you're going to be fingerprinted, go through the process, and released. So what Philadelphia has chosen to do is simply not take these people into custody and hold them to reduce the volume in holding cells, and that hopefully will help control the spread, which is our goal here. So crimes like drug possession, retail theft, DUI. Now, I'm not sure about that one because there's a public safety issue. Perhaps they're stopping people, citing them, and then impounding their car or taking their keys, something like that, or requiring them to simply leave the car there or have a friend pick them up right there on the spot. That may be. I'm not sure about that one, but the retail theft and the drug possession, I actually agree with it because, again, it's all about controlling the volume. So just keep in mind that Philadelphia is not looking away from crime. They're simply just trying to find ways to reduce the spread and citing people who would otherwise simply be released 12 to 15 hours, and that's in Philadelphia. In many counties, smaller counties like Montgomery, Bucks, Delaware, Chester, all places that are law firm services, you're going to be released a lot faster. In New Jersey, the same way. So we're just simply, what Philadelphia is doing is trying to reduce that population. Okay, next question. Is retail theft a misdemeanor or felony crime? Well, that's kind of comes off the first question, but retail theft in most situations, the answer is it depends, really. If it's under $150 in Pennsylvania, it is actually a summary charge if it's your first offense, where the maximum punishment is 90 days of incarceration. And you're probably not going to serve any jail time, but that's the maximum punishment. It's not a misdemeanor. It's less than a misdemeanor. It can actually be expunged from your record if you remain arrest-free 10 years from the date of the conviction, assuming that you are convicted. But in most situations, you're probably eligible for some diversion program, like an ARD or a summary diversion program, which will allow you to do some community service, pay a fine perhaps, in exchange for the withdrawal prosecution. And that's another point to keep in mind, that in cases where people in Philadelphia seem to be concerned about police not arresting people for retail theft, you have to understand that in most situations, the person's not going to be held, and in the grand scheme of things, that person's going to receive a diversion program in which they're not going to have any type of criminal record anyway. So that's an important point. In other situations, if it's your second offense and it's $150 or less, it's a misdemeanor offense. If it's over $150, it is a misdemeanor, and if it's over $1,000 or it involves the theft of a car or a gun, in those situations, it's a felony of the third degree. So in that situations, retail theft can be, well, theft in general can be a felony charge. So it kind of varies depending on the value or the item in question. So, and obviously if you're charged with a felony offense, that would dictate potentially how bail is set. So keep that in mind as well. Next question. Do I need a license to buy a gun in Pennsylvania or New Jersey? Well, I've kind of talked about this in previous podcasts. You don't need a license to buy a gun in Pennsylvania. You do need a purchaser identification card to buy a gun in New Jersey. The fact that you can buy a gun in Pennsylvania or New Jersey doesn't mean that you can simply carry it on your person without a permit to carry. People often confuse that. They for some reason believe that once they buy a gun, they can take and do with it what they want, and that's simply not the case. So the ability to purchase and the ability to carry are two separate issues. Now, in New Jersey, I've written blog articles on this that are available on GamboneLaw.com. You need a permit to carry just like in Pennsylvania, but a permit to carry, a concealed carry permit, is very difficult, if not impossible, to get in New Jersey. Some people can get it, but it's a process whereby you basically have to tell the court why you want the gun, and you have to cite some extraordinary reason, your personal safety, and even then the court may not grant it. Further, in most situations, the only persons who can obtain a permit to carry are usually prior law enforcement or a person in a position where they need that gun. So it's very difficult, and some would say impossible, to obtain a concealed carry permit in New Jersey. Now, in Pennsylvania, the process isn't as stringent, but nevertheless, it's a process. And unlike an ability to purchase, you can be denied the ability to carry even if you don't have a conviction. So, for example, in the case of an expungement, many people who are charged with a variety of crimes, in many cases a violent crime like an aggravated assault or a robbery or a burglary or even a drug case where the charges are later dropped or withdrawn or the case is dismissed following a motion to suppress, those people can be denied a permit to carry just based on their criminal history. I know it sounds unfair, but again, the person who decides that in Philadelphia County would be the chief of police. If you're denied a permit, you have the ability to appeal it, and you have to go through the license board. But that's a process. But don't think that simply because you have your record expunged or sealed, that in and of itself is going to allow you to get a permit to carry. You still can be denied. And I tell people that to really, tell them when they come into the office that if you're asking me to expunge your record, know up front that the expungement may not be enough to allow you to have a permit to carry. Now, if you're denied the permit to carry, your record's been expunged, I would definitely file an appeal and get in front of the board with your lawyer and explain what happened and try to convince the board that you should be allowed to carry a weapon concealed. Don't simply just take their letter and just assume that you wouldn't qualify, because every situation is different. In New Jersey and in Pennsylvania, if you don't have a license and you carry, it's a crime. In Pennsylvania, it can either be a felony or a misdemeanor charge under 6106. In New Jersey, it's not only a felony charge, but there's also a mandatory minimum sentence of 42 months for unlawful possession of a firearm. Pennsylvania doesn't have a mandatory minimum sentence, but nevertheless, in most situations, it will be a felony. It can be graded as a misdemeanor. It would only be graded as a misdemeanor of the first degree if you're facing no other criminal charges. And in Philadelphia, there's a separate misdemeanor charge of carrying a firearm on the streets of Philadelphia without a license under 6108, which is a misdemeanor, which would create a felony charge for the 6106 charge. So keep that in mind. Next question, and our final question. I've been charged with DUI, and I've heard something about a wet reckless as an alternative plea. Is this a good idea? Well, like all of my answers, my immediate answer is it depends. A DUI charge in most situations will subject you to a mandatory minimum license suspension of 12 months. Now, there are situations where you can obtain an occupational limited license, and you may qualify for that. and you maybe can obtain that license immediately, but just based on the surface of the statute, a DUI typically carries an immediate 12-month license suspension. Now, there are situations where you wouldn't face a license suspension, and the only one would be a general impairment DUI under Section 3802A1 without accident, and that is the only situation. That is the lowest level DUI, first offense. There is no license suspension. So it really depends on what you're being charged with. Reckless driving is not a misdemeanor. It's a summary offense, so it's a lower graded charge. There is a mandatory minimum license suspension of 6 months as opposed to 12 months, so there's a benefit there. But you have to look at what you're really charged with. It can be a good alternative, but it's also important to understand that before you speak to your attorney about a plea or a plea alternative, you want to consider several things. If it's your first offense, are you eligible for ARD? Now, you may not be eligible for ARD because you have some prior criminal issue, usually a conviction. You can be denied for ARD or a diversion program if you've been arrested and for some reason the charges were withdrawn or the prosecution was dismissed. Remember, ARD is a discretionary program. They don't have to give it to you. The second issue is, what are your possibilities of success at trial? And when we discuss trial, it's also important to understand that we're talking about both the trial issues and pretrial issues like motions to suppress evidence based on a lack of probable cause to stop your car or lack of probable cause to arrest you for suspicion of DUI. So a wet reckless, while the gradation of it would be less than a DUI, the license suspension would be less, 6 months as opposed to a year. That isn't the only part of the analysis. You have to really kind of go through it and compare what you could receive if you're convicted for the DUI versus the wet reckless. And also, obviously, if you're trying to negotiate a plea, the DA's office has to agree with it. And that would have to be negotiated. And if they're not going to agree with it, at that point in time, that wouldn't be an option anymore. So your attorney should advise you of that. So these are all the questions I have. I just want to stress enough that right now it's important to practice social distancing, avoid large gatherings, avoid just large-scale social contact. You want to avoid going to bars, restaurants. I hate to tell you not to support local businesses, but right now the important thing is to kind of keep everyone safe, including your own family. If you have to travel, make sure it's essential travel. I myself am not taking my children anywhere. They're pretty much confined to our house and playing on their own in our yard or just going for a walk in the streets around our home. And I believe really that's what I'm recommending to all of my friends and family. We have to do that right now. I know right now the kids obviously are all disappointed that the weather's getting nice and they can't play with their friends, but it's the right thing to do. I mean, they've canceled pretty much everything, but again, this is what we're trying to do is avoid spreading this virus, even though there's probably little chance that any of us will get it. Our movement is going to simply increase the chance that it's spread. So again, be safe, practice safe movement, and really just watch out for your friends and family. I wish you all the best, and I will see you next week.